This judge was fed up with this scamming mom's endless excuses for her appalling behavior, so he made sure to give a karmic verdict that crushed her from every angle.
It's starting first with the income tax exemption. The parties have language in their judgment of divorce which states that the plaintiff will claim one minor child each year, defendant will claim two minor children each year for the purpose of tax deductions on their federal, state, and local tax return. Plaintiff did not follow this provision in the judgment of divorce. She claimed all three children as income tax dependents. This caused my client great financial harm. This is something he relies upon, that he plans for. So we're asking the court to rectify this. Lastly, Your Honor, as it relates to parenting time, now we've got a 13 and 16-year-old. They go back and forth between these parties' homes 4 times in a 2-week period. They have asked repeatedly for a week-on, week-off schedule. When my client approached Ms. Adams about it, she said, nope, we're not making any changes. So we do believe her agreement to that provision was disingenuous at best.
It was brought to my attention years ago through seeking legal counsel and counsel from multiple accountants that according to the IRS tax law, whoever the children reside with more than 50% of the time.
Okay, ma'am, let me interrupt you there. That's true. The IRS code does provide for that unless there is a subsequent or a different order as it relates. In this case, you had a judgment that did provide for different handling of that deduction. So the IRS code is not applicable in this matter.
Even though he did make more, has a higher income. I was starting my own business, trying to get my business off the ground. I do have, lesser income. So all of these factors, I thought, according to the IRS tax law.
As I stated, the IRS code is not applicable whether there's a judgment in place. So the court is going to grant the motion as it relates, allowing the defendant to claim all 3 children in 2024, which would allow him and make him whole based on losing the exemption in 2023. The last thing is the request for, again, to modify, to change the parenting time to be alternating weeks rather than the schedule that's in place now.
Yes, Your Honor. This is the first time this has come up.
Okay. I don't care if it's the first time or the 10th time. I'm just asking you what's your response.
Yeah, no, my response is that I don't think that it would be in the best interest of the girls at this time, since they have been consistently doing this for 9 years, to go ahead and change that up.
Well, it does appear that the schedule when it was implemented was obviously could be related to their age and not having to have them gone such an extended time. But the court does note in reviewing the motion that, in fact, it does provide, obviously not the consistency that could be provided on a straight schedule. So the court is going to grant the request at this time.